listeners of Radio Go.
I've tried my best to explain what happened at the Court of Appeal, but I am not a lawyer. So for the people who are listening to us, explain to us how this issue of submission of no case works, and how come they have to go all the way to the Court of Appeal to get a decision of a trial court, a judge overturned, and what this will mean to the case?
Well, the foundation of our criminal justice system, which we have for several years copied from Great Britain, is the presumption of innocence of any accused person. The law presumes that an accused person is presumed innocent until he is proven guilty, or otherwise that accused person pleads guilty. And this principle has this expression in all the various procedures and processes adopted during the trial of criminal cases. Indeed, this common law or England law principle has been codified into our Article 9 of the Constitution. And it is for this reason that the burden of proof in criminal cases is so heavy. That is to say that unlike civil cases where it is the burden and the standard of proof in particular is said to be on the balance of probabilities. In criminal cases, the proof is beyond all reasonable doubt. And the accused person, right from the time of arrest and all those processes of being charged and the charges prepared and filed, but it's not even required by law to say anything. That is why police in their caution statement that you are not obliged to say anything. So the right of silence is also constitutionally recognized. So throughout the trial, the prosecution bears that burden of proof. In other words, to lead sufficient evidence to discharge the burden, but to prove that it is the accused person who has committed that offense. And for every offense, such as the particular one under the law of causation of financial loss, there are what we call essential ingredients. In other words, there are certain elements of the offense. Every offense has elements or ingredients to be proved. Okay? This offense under which the former Deputy Minister of Finance and Mr. Japa and one other were charged first came to be tested in the case that was popularly referred to as the quality grain case. That is the Republic versus Ibrahim Adam and others, where the court for the first time was confronted with defining and determining the very essential ingredients of that offense. I recall a student of criminal law at that time, I think between 2001 and up to during the early days of President Kufuor, where that offense was being tried before Justice Afrey. It was very difficult to actually determine what the essential elements are, because it had never been, nobody had ever been charged under the provision. Okay, you know, it is not just enough in every criminal offense, except those that are described as strict liability offenses. Okay, this is an offense which we will describe as liability with fault. The strict liability offenses are offenses without fault. In other words, there is no need, apart from the physical act of commission of the offense, the mental state of the person in doing so had to be proved in this case. In street liability offenses, there's no need to find out why the person reported it. For instance, if you jump a traffic light, the fact that you drove through the red light is enough that you have committed an offense. There's no need for the police or the prosecution to find out why did you jump the light. But in this particular case, both the physical element of commission of the offense and the mental state of the accused person must be established on all fronts. So the question is it intentional? At the time of the quality brain case, the court went at great length. And I remember, I think, is it Mr. Kokuba, who was one of the lawyers or so, tried to argue, because this mental state is seen in different manifestations. It may be described as intentional. So the intention or the intent, the necessary intent, must be proved. It could be expressed in the way of negligence. Okay? Sometimes it's described as recklessness. Another time it could be willfulness, and so on and so forth. In this particular offense, the word is willful causation. That is willfully causing financial loss. So, the question that the trial court was confronted with by the time that the prosecution closed its case, called the last witness, was to determine first whether there was indeed a loss of money or property of the state, and whether that loss was caused by the accused person. And if the loss was caused, whether the loss was willfully caused by the accused person, in particular the minister. All that the minister was alleged to have done was that he authorized an LC. And this authorization, per the evidence as we are all following, was authorization that he did on behalf of his boss, the minister himself. Okay? So it was in fact act of the minister. But by authorizing an LC, was it sufficient to suggest that Honorable Adefonsin, when he authorized the LC, willfully intended that the LC be converted to cash to cause any loss to the state? Why would a minister, a deputy minister, whose only duty, it wasn't his ministry, but another ministry, as the actual party, that is the health ministry, entry into a contract with a company with agency, presence in Ghana through Mr. Japan, Deep Sea. We want to bring ambulances for use of the ministry. We'll authorize an LC, which is like a security, to give comfort to the exporter, that when we bring these goods which we have ordered, we are guaranteeing that once delivered in a certain state that as agreed, you will be paid. Why would the minister in this circumstance be described as someone who has willfully caused financial loss, when the circumstances, the evidence, even as it is being explained in the ongoing trial by Mr. Japa and other witnesses who are experts in such transactions, will be said to have been the one cause. In any case, even if there was financial loss at all, there must be a causal link between what the minister did and the loss. What role did the minister play after authorizing the LC? the Minister for Finance does this routinely on behalf of all ministries whenever necessary in the performance of their functions, public duty. But the particular departments, agencies, and ministries own their contracts that they enter into. So if something untoward happened, assuming that anything wrong happened at all subsequently or subsequent to the authorization of this else, what is the causal link between such acts of the ministry or the ministers or subsequent ministers or directors or those civil servants be connected to the initial authorization by the minister? So at the end of the trial, of the prosecution case, when the prosecution has called the last witness, the law requires that the trial judge will evaluate all the evidence at that stage and then come to the conclusion that at least the prosecution has been able to establish all the essential elements of the offense. That at that stage, the accused person could be deemed or presumed to be innocent unless he or she offers an explanation. At that stage, the constitutional or legal presumption of innocence is said to have shifted. So the accused person can no longer be presumed to be innocent. But that is the burden is beginning to shift, and the presumption of innocence, we said that there is some presumption of guilt unless and until there is an explanation to the contrary. That is when it is said that the prosecution has made a prima facie case. In other words, on the face of the evidence presented by the prosecution, all the essential ingredients or elements of the offense have been established. What the accused person is required to do from then on is call upon to open his defense. And all that the accused person is required to do is to call in sufficient evidence to rebut the presumption of guilt by raising what we call reasonable doubt, a doubt as to the offense of guilt. Now, when the prosecution called the last witness and the judge was to determine this, the accused person, Mr. Atifosin and Mr. Jakpa's lawyers, made a submission of no case. It's also a right provided for under the Criminal Procedure and Offences Act, that is Act 30. It's a procedure allowed. So there was a submission of no case. And what does that mean? The accused person simply said that, look, despite all the evidence that you have called or witnesses that you call, you have proved nothing. You have not provided the sufficiency of evidence as required to establish our guilt or the essential ingredients. Now, at the submission of no case, the court has to determine certain things. One, the accused persons will simply say, for instance, that either no evidence was called, or that even though some evidence was called, the evidence has become is not sufficient. Either some of the elements of the offense have been established, some were not, or none of evidence produced was capable of establishing or proving any of the essential elements of the offense. Again, at that stage, the accused person also said that, yes, although there was some evidence, the evidence was so discredited and became so unreliable as a result of cross-examination of the witnesses that no court could reasonably convict on them. Or, although there was some evidence, the evidence if carefully evaluated, is open up to two or more meaning. In other words, to some extent, the evidence will point to the guilt of the accused person. Look at it from the another angle will show that it points to the innocence of the accused person. If the evidence produce such a result, it is for the trial court to determine whether there was indeed a case for the accused person. Because the right to silence, and the right presumption of innocence still remains throughout. So if you are calling on the accused person to open his defense at the submission of no case, it must be clear that indeed there is a case to answer. But the trial court roundly overruled the submission of no case and quickly call on the accused persons to open their defense. And it was on the basis of this ruling on the submission of no case that the lawyers for the two accused persons filed an appeal. It is this appeal that was determined yesterday. And whilst this appeal, it was an interlocutory appeal. Interlocutory in the sense that it was not an appeal filed against the final judgment or decision of the court. It was only in respect of some decision while the matter was still pending before the trial court. So it was interlocutory. And while this appeal was pending, the options left to Mr. Afonso and Mr. Jakpa's lawyers included an application to the trial court that, look, we have launched an appeal against your ruling on the submission of no case. Please wait so that we will go and pursue that appeal, and depending on the outcome, we'll come back. That is what we often call a motion for stay of proceedings pending an interlocutory appeal. That was done. The trial quickly dismissed the motion. And I think Mr. Atufosin's lawyers also went further to the Court of Appeal to apply for a stay of proceedings, simply saying that we filed an appeal which has a very high probability of success. Could you please ask the trial court to wait and not rush the trial until this appeal is heard? That same Court of Appeal also dismissed the motion for stay of proceedings and asked them to go and open their defense. And you can see that Mr. Atufosin has even concluded his case. And then it is now the turn of Mr. Jakpa, who is still in the witness box, and having been discharged, we are told he intended to call as many as the 12 or 8 witnesses. And the trial was being rushed in such a manner in total disregard for the pending appeal. The meaning of this ruling yesterday or judgment is to bring finality to the matter. In fact, it was the second time hearing of the submission of no case. That appeal is about a rehearing of the submission of no case which the trial court had refused.
If it bring finality to the case, because this one was filed by lawyers for Dr. Kesela Atufosin. There's still Richard Jakpa and Big C.
Yes.
What happens to them?
From what I've been away from Accra since Sunday, and I'm just following this in the media. But from all indications, the judgment yesterday, although sometimes they were referring to Mr. Atufosin as the appellant, also talk about the third accused person, because the offenses were interlinked. I mean, they were charged jointly and severally. Okay? And in matters of, say, I believe that there is conspiracy or abetment and others, where one person is acquitted and discharged on such offenses that are interlinked, the other person will not have anything to answer either. The court stated that by calling on Mr. Atufosin to open his defense, was an error of law committed by the court and the trial court. And by the same reasoning, Mr. Japa was equally not required to have opened his defense. The matter effectively has been brought to an end.
I see.
Don't forget that an appeal is said to be by way of a rehearing.
Okay.
Every appeal, whether on a point of law or fact, is a rehearing of the case appealed or decision appealed from the trial court. So the appellate court is said to be in the same position as the trial court. Look at the whole of the record, the entire record. Evaluate the record both on the evidence, that is, on the facts, and also on the law, and to come to its conclusion. The appellate court can affirm the position of the trial court or the court below, or vary it partly or wholly, or substitute its own findings or decision with that of the trial court. And so the appellate court is not limited to any aspect of the findings or on the law or on the facts by the court below.
Now, having said that, I'm sure you have by now heard the Attorney General's response.
It is normal, is it not? Has this Attorney General, and particularly this government, have they ever accepted any loss in court? For the last 7 years, what has become very, very common and predictable about this government and the Attorney General is that they never accept one single defeat in court. They must always win in every court. That has been the attitude of this Attorney General. Every case this Attorney General will have to win. In our legal profession, I mean, yes, it is the right of every party to express opinions about decisions of the court. And it is also every lawyer or party's right to explore other options after a decision. Yes, the option for appeal is there. It has always been available to accused persons as well as the Republic. But for once, one should expect the Attorney General to learn to accept defeat. No lawyer worth his salt will carry such inglorious credential of a bragging right that I have won every case in my life. Then there must be something wrong with you. You can't win all the time. Sometimes, as lawyers, we must be very, very courageous and magnanimous. And in defeat, we must accept defeat. That's also a good sportsmanship.
But is it not right if he feels that the judgment was completely wrong and he still feels that, yes, there's a case? It's not right to go to the Supreme Court.
He is entitled to go to any court. Okay? He is entitled to do so. But what at all is the Attorney General's interest in all this? We are talking about willful causation of financial loss. And this Attorney General was never interested in the option of Deep Sea's offer. The offer to refund the money. He was very interested in restoring a restorative kind of justice where the money will be refunded if indeed the state's interest is in preserving or protecting its resources or property from any loss. They are not interested in this and fail to take advantage of that option. And now that money is gone as a result of some failures on the part of the ministry itself to have the full benefit of these that were brought together with all the accessories that were left to rot. That it is join process in recovering the money, but he's going to chase the wind again, it is the prerogative of the Attorney General. He must be entitled to do whatever he wants to do, go to whatever court. But I'm saying for once, this Attorney General must learn as a practitioner, okay, accept defeat.
Lawyer, thank you very much for speaking to us.
You're welcome, Senator. Have a nice day.
You too, Lawyer David AMETEFE is a private legal practitioner. Always a pleasure talking to him. Broke down everything for us, how the whole process is supposed to work, and what this will mean to the whole trial. Remember, there's been a trial at the courts. Mr. Dr. Kesela Tufosin's lawyers opened his case and closed it.